Hello and welcome to our latest webinar. I'm Jeremy Glover, a partner here at Fenwick Elliott, and this week I'm very pleased to be joined by two of my colleagues here at Fenwick Elliott, Sam Tyne and Olivia Leone. They've both been working with me on a couple of infrastructure projects in Africa and Eastern Europe over the past few months, so I know they're very well placed to discuss with you some of the more recent developments in the international field. Now, I joined Fenwick Elliott over 23 years ago now, and we've always had very strong links with New Zealand and Australia. And you'll hear that Olivia and Sam are two more in the long line of excellent lawyers who've come from that part of the world. So what are we going to be looking at today? Well, we've got a full spread of topics for you. I'll look at prescription management processes in standard forms, look at multi-tier dispute resolution clauses, witness evidence, conflicts of interest in relation to experts, and a quick discussion about the impartiality of arbitrators, which will also touch on the question of conflicts of interest as well. But before I go on, the usual housekeeping, you're all on mute, and if you have any questions, please feel free to drop them into the question box. All questions will be asked anonymously. And we'll also provide you with a copy of the slides after the event. So, looking at prescription and management processes in the standard forms. And in many respects, that heading is longhand for notices. But I'm well aware that lawyers always talk about notices, and I didn't want you all to switch off. But why do lawyers always talk about notices? It's because notices lead to dispute. A failure to serve the appropriate notice leads to dispute. A failure to understand what notices you're actually required to serve will actually easily lead to disputes. So we thought we'd kick off with a quick refresher about how the courts have been treating the question of notices, this time in Hong Kong, where there was a tunnelling project, and the contract provided that if the subcontractor wished to maintain its right to pursue a claim, the subcontractor, as a condition precedent to that entitlement, within 28 days of giving the initial claims notice, had to submit in writing to the contractor details of the contractual basis on which they were making that claim. Now, many of you will be aware that there's a similar requirement to provide details of the legal basis of the claim in the new 2017 FIDIC form. And what happened here was that MIDA gave notice of the contractual basis, but the dispute rumbled on. And when it came to arbitration, MIDA was successful, but through a different contractual route, and they hadn't given notice about that. Now, the arbitrator had found a way to get around that problem, but the Hong Kong courts did not. At first instance, the judge, Mimi Chan, she said that however much sympathy a contractor may deserve, Clause 21 employs clear language, it employs mandatory language. It's crystal clear what the obligation on MIDA was. And what the court and an arbitrator couldn't do was rewrite the clause after the event. And that case went to appeal, and the Court of Appeal judgment came out at the end of last year, and the Court of Appeal agreed with Judge Mimi Chan. You couldn't rewrite the clause. The language was clear, and therefore MIDA were bound by the original condition precedent. So there's nothing new here. It's just a reminder, as always, of the importance of notices and the need to take care to comply with notices provisions. You don't want courts to be expressing sympathy with your position. That's never going to be a good sign. But with that reminder about notices, Olivia is now going to look at the multi-tier dispute resolution clause. So Olivia, over to you.
Thanks, Jeremy. So as Jeremy mentioned, I'm going to be looking at multi-tier dispute resolution clauses today, specifically in relation to Republic of Sierra Leone and SL Mining Limited, which was a recent case in which the English High Court dismissed a challenge to an arbitral tribunal's jurisdiction under Section 67 of the Arbitration Act. So the decision is significant because, amongst other reasons, it's the first one from an English court to give detailed consideration to the distinction between jurisdiction, being whether the tribunal has the power to hear a case, and admissibility, being whether it's appropriate for a tribunal to hear it. So just to quickly summarize the background, the underlying arbitration related to a mining license granted by Sierra Leone to SL Mining, A dispute arose after Sierra Leone purported to suspend and subsequently to cancel the license. The mining license contained a multi-tier dispute resolution provision, which I've included on the slide, but essentially the clause required the parties to try to settle any disputes for a period of 3 months before commencing any arbitration proceedings. In terms of how the Section 67 challenge developed, SL Mining first issued a formal notice disputing the cancellation on 14 July 2019, triggering the start of the 3-month negotiation period. SL Mining then proceeded to serve its request for arbitration on 30 August 2019. So that was approximately 6 weeks before the 3-month negotiation period would expire. Sierra Leone then unsuccessfully tried to challenge the tribunal's jurisdiction to hear SL's claims. That challenge didn't succeed, and the tribunal concluded, by way of a final partial award, that it did have jurisdiction. And then Sierra Leone applied to the English High Court to set aside the award under Section 67 of the Arbitration Act. So before we move on to what the court decided, it's worth taking a moment to look at the provisions of the Arbitration Act. So the default position in England is that the tribunal has the ability to rule in its own jurisdiction. However, Section 67 allows a party to arbitration proceedings to seek a declaration setting aside an award on the basis that the tribunal lacked substantive jurisdiction to make it. Substantive jurisdiction is defined in Section 30, subsection 1 of the Act to mean one of 3 things: whether there is a valid arbitration agreement, whether the tribunal is properly constituted, and what matters have been submitted to arbitration in accordance with the arbitration agreement. So Sierra Leone relied on the last point of the Act. It argued that the dispute had not been submitted to arbitration in accordance with the arbitration agreement because SL Mining had commenced arbitration proceedings prematurely, i.e. before the expiry of the 3-month negotiation window in the multi-tier dispute resolution agreement. So the key question for the court was whether Sierra Leone's challenge to the prematurity of the request for arbitration was a matter of substantive jurisdiction under Section 30, subsection 1 of the Arbitration Act. It was common ground between the parties that there's a distinction between jurisdiction and admissibility. Put simply, jurisdiction refers to the power of the tribunal to hear a case, whereas admissibility refers to whether it's appropriate for the tribunal to hear it. So to try to figure out whether Sierra Leone's challenge went to jurisdiction, the court looked first at leading academic commentary. The court quoted a number of academics, including a textbook authored by Gary Bourne, a leading international arbitration lawyer and academic. I put the relevant extract up on the slide, but in summary, Bourne's view was that there should be a presumption that procedural preconditions to arbitration are not jurisdictional for 2 main reasons. The first reason he provides is that tribunals are best placed to decide these issues. That's because the requirements for cooling off or for negotiation periods inherently involve aspects of arbitration procedure and often require interpretation and application of institutional arbitration rules or procedural provisions of the arbitration agreement. As well as that, any remedies which the tribunal might award for breach of negotiation or timing requirements will necessarily involve procedural issues concerning the timing and conduct of the arbitration. The second reason Bourne provides is that parties who choose arbitration presumably want a single centralized forum for resolution of their disputes, and on that basis it'd be more objective, efficient, and fair for a single neutral tribunal to resolve all questions regarding procedural requirements. In addition to looking at the academic commentary, the court also examined decisions by national courts and other major international arbitration venues. So the US Supreme Court had previously found that disputes about procedural condition precedents to arbitration should be resolved by tribunals, and the Singapore Court of Appeal had also concluded that objections regarding preconditions to arbitration are matters of admissibility, not jurisdiction. So on the basis of that review, it was pretty clear that the international authorities overwhelmingly thought that preconditions to arbitration didn't go to jurisdiction. Ultimately, however, the court said that under English law, the matter boils down to whether a premature reference to arbitration could fall within the definition of substantive jurisdiction under the Act. On that point, the court found that If the issue relates to whether a claim can be brought to arbitration, the issue is ordinarily one of jurisdiction and subject to further recourse under Section 67 of the Arbitration Act. If the issue relates to whether a claim should not be heard by an arbitral tribunal at all, or at least not yet, the issue is ordinarily one of admissibility, the tribunal's decision is final, and the claim does not go to substantive jurisdiction under Section 30, subsection 1 of the Act. In interpreting what does go to substantive jurisdiction, the court found that this comes down to whether an issue is arbitrable. Here, Sierra Leone's challenge did not relate to whether SL Mining's claim was arbitrable or whether there was another forum other than arbitration in which SL Mining's claim should be decided. Rather, it related to whether SL Mining's claim had been presented too early. That was a decision best decided by the arbitrators. The court also distinguished its previous decisions in 2 cases before the High Court. In both of those cases, it was assumed that a challenge to a time condition precedent could be brought under Section 67. However, the court noted that in those cases, the distinction between jurisdiction and admissibility hadn't been specifically argued, and it was simply assumed that the matter went to jurisdiction. So on that basis, the court concluded that neither case was binding. In addition to the jurisdiction question, the court also considered whether the 3-month negotiation window in the multi-tier dispute resolution clause was in fact an absolute bar to commencing arbitration. The court concluded that it wasn't, based on the wording of the clause. So it was common ground between the parties that the 3-month period was mandatory and not merely directory. However, the wording of the multi-tier dispute resolution clause made it clear that the negotiation period was subject to the possibility of earlier proceedings if the objective of amicable settlement could not be achieved. So the court thought it was significant in this regard that the 3-month period, which was set out in subclause C of the dispute resolution clause, was subsidiary to and followed after the obligation in subclause B to attempt an amicable settlement. The court said that the tribunal was best placed to decide whether the parties would objectively have been able to reach an amicable settlement if they had had the full 3-month negotiation period. But it did note that Sierra Leone had made allegations of corruption and bribery against SL Mining, and that SL Mining had made allegations of greed, oppression, and ulterior motives by Sierra Leone. So on that basis, the court said it was pretty clear that, as of the date SL Mining started the arbitration, there was, to quote, not a cat's chance in hell of an amicable settlement by the expiry of the 3-month period. So what does this all mean for arbitration practitioners? Well, I think the obvious takeaway is that compliance with precondition to arbitration in a multi-tier dispute resolution clause is not an issue of substantive jurisdiction, but rather a question of admissibility that will be left for tribunals to decide. Aside from that key point, I think the decision should also provide assurance that procedural disputes regarding preconditions to arbitration will be resolved by the tribunal, and that the tribunal's decision won't be then re-scrutinized by the English courts. Another takeaway is that the decision shows the court's willingness to take a commercial approach to interpretation of dispute resolution clauses. I think on this front, the court's finding that the negotiation window did not impose an absolute time bar was based on the specific wording of the clause, but it's also consistent with commercial common sense. Parties are unlikely to have intended a negotiation period to act as a complete bar to arbitration in circumstances where there isn't a cat's chance in hell of settlement. That said, I think it's important not to regard the decision as providing permission to ignore escalation requirements in all multi-tier dispute resolution clauses. The court didn't suggest that these requirements will never be an absolute bar in all situations where settlement appears to be a remote prospect. I think this is all the more important when you consider the potentially expensive consequences of any failure to comply with these dispute resolution clauses. If the proper steps haven't been complied with, an arbitral tribunal has the power to stay proceedings with the duration of the negotiation window and or to impose cost sanctions. And if it concludes that pre-arbitration steps are an absolute bar to proceedings, the tribunal could determine that a premature claim isn't admissible, and in that scenario, you might be placed in a very unenviable position of needing to appoint a new tribunal after you've gone back to go through all the preconditions in the dispute resolution provision. So to conclude with a few practical pointers, if you have a multi-tier dispute resolution provision, you should seek to comply with any escalation requirements. And it should go without saying that this is all the more important if the requirements are mandatory and if there's any possibility that they might be interpreted as imposing an absolute bar to the commencement of proceedings. So on that note, I'll hand back over to Jeremy now.
Brilliant. Thank you very much, Olivia. It would have been interesting to know, or at least interesting to have seen the potential witness evidence in that case, which caused the colourful, for a court at least, commentary about the cat's howl in chance. And the question of the extent to which courts and arbitrators can rely on witness evidence in the traditional sense is very quickly becoming a very hot topic in the judicial world. And I think the issue is this: it comes down to the question of how reliable is witness evidence. And I know that in the advertising for this webinar, we promised you at least one reference to Newcastle United, and the Ashley in the case on your slide is Mike Ashley, the chairman of Newcastle United. And the issue for the judge in this case was to try and decide whether an agreement had been reached between Blue and Ashley in discussions in a pub. And the judge was very clear that the best approach for a commercial case is to place little, if any, reliance on witnesses' recollections of what was said, but to base actual findings on inferences drawn from the documentary evidence and the known or probable facts. So there's a question mark being raised about the witness evidence. And some of you may know that there are new rules about the use of witness evidence in the commercial courts of England and Wales. But what we wanted to do today was just comment very briefly on a recent ICC report about the accuracy of fact witness memory in international arbitration, which raises or discusses some of the concerns raised by Mr. Justice Leggett in the Mike Ashley case. And it highlights some of the potential issues with witness evidence and the concern that memory may be influenced. So therefore, you might have a witness standing up before a tribunal and they are entirely credible, and that because they believe what they're saying is true. And the concern that is being expressed is that, well, they may be absolutely convinced that what they're saying is true, but their memory has been influenced by what's happened previously. They may have been influenced by discussions between with co-workers, with potential witnesses. They may have been influenced by discussions with in-house counsel, with external counsel when it comes to drafting submissions. And also they may have been influenced by the submissions themselves. Witnesses routinely get the chance to read statements of case or adjudication referrals, and they see that the case that's being put forward. And there is a concern that's been expressed that taking all this together can lead to a risk of memory distortion. And that's one of the issues that has been highlighted by the ICC in their report. How can you reduce these distorting influences? Well, the key is keeping contemporaneous written or notes of issues being discussed at the time the relevant events unfold. And that can actually be before the people are actually aware that there is a dispute. And you should also remember that many contracts actually require claims to be based on contemporaneous documentation. So the keeping of contemporaneous notes is fundamental importance. Obviously, you need to emphasize to witnesses the importance of their own recollections. Try and interview people at the earliest opportunity. The earlier you can speak to people, the better, the more likely their evidence is going to be accurate in the sense of it's their recollection. It's not their recollection as influenced by outside sources. And then fall back to consider what extrinsic, neutral, contemporaneous evidence. What do the documents actually say? And you see that in the ICC report, they talk about the importance of good record keeping and contemporaneous notes during the course of a transaction, during the course of a project. The notes are actually being taken pre-dispute. Now, they provide good evidence of what happens, and that's the type of document that should be being used to refresh a witness's memory. Those of you who may have attended our webinars on claims last year when I was discussing preparation of claims with Lynn McCafferty QC of Four Pump Court and George Taft from Secretariat, you may recall the Australian case of White and PBS Holdings, where the judge considered the general witness statements from the people who were on the project, but what the judge preferred was the primary contemporaneous source of evidence, the site diary. And the site diary was standard basic record keeping that was being kept on the project before the dispute emerged. It was just progress on a day-by-day basis. So that was the best evidence of what actually happened on that particular site. You may also recall that the judge in that instance decided not to accept the evidence of the two delay experts and actually relied on the expert that the judge, so court-appointed expert that the judge made himself. But a rather different issue emerged with experts in the Secretariat case that Sam is now going to talk about. So Sam, over to you.
Thank you, Jeremy. Yes, as Jeremy said, I'm going to be discussing the recent Court of Appeal Secretariat decision, and it concerns conflicts of interest, which conflicts are a dilemma that I'm sure many of you listening are familiar with, as practitioners often find themselves in situations where they realize that the industry is perhaps not as large as it seems, and you end up faced with having to turn down work due to a conflict of interest. And it's a position that practitioners, especially good practitioners, often find themselves in. And I want to say at the outset that when looking at this case in the cold light of day, the temptation is certainly there to think that it's a situation that you could easily have avoided if you were in that position. But I think this is a trap, because at the end of the day, we all want to do work, and we'll look for reasons why we can do the work and perhaps not look so hard or pay too close attention to the reasons why we can't do the work. So this case is a cautionary tale in that respect, which is why I think there's a bit of value in discussing it. So the whole case is summed up by Lord Justice Colson when he discusses the lack of precedent on the subject, and he describes it as follows. So he says, no English case has addressed head-on a dispute in which there are two existing litigation support / expert retainers, which each client wished to maintain, relating to two live arbitrations where the respondent says the same expert organisation will be supporting, advising and giving evidence for and against the same client about the same project and the same or similar subject matter. So I appreciate that's a bit of a mouthful, so we'll just talk a little bit more about what actually happened. And the situation broadly is that a developer of a large petrochemical plant in Asia was seeking an injunction restraining a delaying quantum expert from acting as an expert witness for a third party in an ICC arbitration against them. So this was because the expert was also acting for them against a different party, a subcontractor on the project, in a dispute that had arisen, which had many overlapping issues. So adding another layer of nuance is that Secretariat, being an international organisation, had different entities within that broader group carrying out the work on each of those instructions. Now, just running through that again, I've tried to represent it visually. So we've got our two existing litigation support / expert retainers relating to the two live arbitrations. So the first between the subcontractor and the developer, and the second between the developer and the third party. And the respondent here, the developer, says that this is the same expert organisation. They're acting for and against the same client, and it's all about the same project or similar project with, same project with similar or the same subject matter. So looking at all this, it's important to consider why they thought there might not be a conflict here, which kind of explains what happens next. So I've put on the screen a quote from an email that was considered as part of the proceedings. I'm not going to read the whole thing, but essentially the expert here is making the distinction between the two entities. So one of them was outside of Asia and the other one was inside Asia. They note that the third party that was instructing the international entity didn't consider there to be a conflict, although I'd suggest that the use of the word seem there doesn't inspire too much confidence. They also note the differing scope of the work and the arbitrations that they're advising on, and they note that they have capabilities within the firm to manage the conflict. But it is important to note at this point that even hearing all of this, the developer still responded and said that they think there's a conflict here. And curiously, the issue doesn't seem to have been taken any further. So you could imagine the developer's shock when, in the course of the dispute with the third party, they received expert schedules that was prepared by their expert. So that leads us to the TCC decision last year, where the developer went to the courts and received an interim injunction and were seeking to continue that. And they wanted to prevent the international entity, so SRUL, from doing any further work on the second arbitration. So here, the TCC found that there existed a fiduciary duty of loyalty between SCL and the developer. The duty extended to the entire group, so SRUL was captured by that same duty, that a conflict existed, and that the injunction could continue. And you know, this many looking at these facts may not be too surprised by the decision, but what did get people excited, and by people I probably am more accurately referring to a handful of lawyers, was this ruling that the fiduciary duty existed between an expert and their client. And it was this decision that was the focus of the bulk of the Court of Appeal's reasoning. So that leads us to the little discussion on fiduciary duties here. And Lord Justice Colson said in the decision, which I think is quite apt, that the expression fiduciary is freighted with a good deal of legal baggage, and that's certainly no understatement. Fiduciary relationships are one of the most sacrosanct relationships under law, and one of the main characteristics is that they exist where one party is in a vulnerable position of basically relying wholly on the other party to act in their interest, and therefore an exceptional level of trust and confidence in that party is required. So the classic examples are a lawyer and a client relationship, and a trustee and a beneficiary relationship, where one party is relying wholly on the other one to act solely in their best interest. So it was no small thing for the court to sort of formalize the expert-client relationship in a fiduciary context. Now, usually they are confined to these pre-existing categories, which is why it's the subject of the appeal here. So, looking at the Court of Appeal decision, the court had several issues to address, and these included whether or not the entity within the expert group advising the developer owed the fiduciary duty of loyalty. If there was no fiduciary duty, was there a contractual duty in place? If there was a duty of either kind, did that duty extend to all companies within the expert group? And if it did extend, was there a conflict of interest in respect of the engagement by the third party on the second arbitration? So looking at the first two issues there, as they're sort of connected, a large chunk of the decision was dedicated to these questions and exploring the relationship between an expert and their client. And ultimately, the court decided that here there was no purpose in designating the relationship as a fiduciary one, given that there was a contract in place which had a conflict of interest provision which dealt with the matter sufficiently. So that answers the second question, which is the duty was a contractual one. Did it extend to all companies within the expert group? Here, the court decided that, based on the facts of this case, the distinctions between the entities in the broader group were immaterial. And this was in a large part due to how the company marketed itself. So I suppose from the perception of the clients, you weren't aware that you were getting one entity versus another. And also in particular, when they carried out their conflict check, it was across their entire group. And finally, was there a conflict? Well, the court here determined that there were significant overlaps in the instructions, and these overlaps were all pervasive, and that a conflict of interest existed. They basically said that, there was an overlap of parties, the role of the expert, the project, and the subject matter, such that this couldn't be reconciled and that a conflict existed. So this sort of leads us to where this case lands on the nature of the expert-client relationship. And at least in this case, the duty was confined to the terms of the contractual relationship, but that doesn't necessarily rule out the relationship being considered fiduciary in some contexts. So Lord Justice Colson states that depending on the terms of the retainer and the relationship between a provider of litigation support services on the one hand and his or her client on the other, may have one of the characteristics of a fiduciary relationship, namely a duty of loyalty, or to put it another way, a duty to avoid conflicts of interest. So the door's not quite closed there. And it's worth mentioning another aspect that was discussed several times in the case, which is if there was a duty of this nature, how would this interact with the expert's overriding duty to the court? And the court notes several times that there's no conflict between these two duties. And I mean, many listening will know that a lawyer also owes fiduciary obligations to their client, but also has their duty to the court, and there's no conflict between these. And finally, and perhaps a relief to many, the court also observed that the case should not be taken as saying that the same expert cannot act both for and against the same client, as it's inevitable that large multinational companies often engage experts on one project and see them on the other side in relation to a dispute on another. So just to conclude with some sort of practical tips, I think here clearly the key issue was understanding the contractual terms of pre-existing retainers when considering taking on new instructions. And not just the conflict of interest provisions, but considering what the instructions are themselves, because the overlaps between the roles on the different projects were a factor in the court's decision here. Acting for multiple parties on the same project is likely to result in a conflict. Company structure is unlikely to provide protection from conflicts, although the court did say that there are ways to manage this, but you need to be quite careful. And if a party advises you that it believes there is a conflict, it is probably best to follow up with this. I think here the parties were quite confident in their positions, and so the further discussions weren't had. And thank you, Jeremy. I'll hand it back to you.
That's really interesting, Sam. Thank you very much. And of course, you've been talking about conflicts of interest, and I think I'd ask everyone to bear in mind just the comment on your final slide, but the conflict of interest is a matter of degree. Because as I think most of you will know, the Supreme Court in the UK late last year in the Halliburton case gave guidance about when arbitrators should make declarations about potential conflicts of interest. And that Supreme Court decision, or the principles of the Supreme Court decision, have now been applied in the case of, and here's your second reference of the day, to Newcastle United, Newcastle United Football Club and the Football Association Premier League. And very briefly, what had happened here was that 2 weeks after the arbitrator nominated by the FA confirmed that no circumstances existed that gave rise to doubts about their impartiality, the Football Association lawyers popped up and said, well, actually, there were a number of matters that hadn't been disclosed. The arbitrator had advised Premier League 4 times in the past. On one occasion, he'd actually advised on the same set of rules that were the subject of the current dispute. Further, the FA's lawyers had been involved in 12 arbitrations with the same arbitrator, and they'd employed or appointed, rather, that arbitrator in 3 of those arbitrations. Now, Newcastle said that that information should have been disclosed upon appointment, and as a result, they invited the arbitrator to recuse themselves. That was an invitation that was declined, so Newcastle applied to remove the arbitrator, including on the grounds that a fair-minded and informed observer would include that there was a real possibility that the arbitrator was biased. So we thought we'd just spend a couple of minutes just asking, who is the fair-minded and informed observer? Well, the test was devised by Lord Hope about 20 years ago as part of the ongoing dispute, saga, scandal in relation to homes for votes at Westminster Council. And the case, part of the case involving a challenge to the district auditor, reached the Supreme Court, and Lord Hope commented that the question was whether the fair-minded informed observer, having considered the facts, would conclude that there was a real possibility that the tribunal was biased. Happily, Lord Hope, some 7 years later, provided more information about who the fair-minded and informed observer was. The fair-minded observer was the sort of person who reserves judgment on every point until she's fully understood both sides of the arguments. She's got to be not unduly sensitive or suspicious, and her approach mustn't be confused with the person who brought the complaint. What about the informed observer? Well, they take a balanced approach. They take the trouble to read the text of the article, and they don't just rely on the headlines. And she tries to put everything that she's read or seen into its overall context. So they're fair-minded, so she'll appreciate that context forms an important part of the material, which they must consider before passing judgment. So what did the judge in the Newcastle case do? Well, very helpfully, he commented about the IBA guidelines on conflicts of interest, which are of fundamental importance to arbitration. He said that they were a practical benchmark against which potential bias could be judged. And then he had a look at the case in the round. So the issue about the arbitrator having provided advice about the rules sounds quite serious, but the rules are massive, and the dispute was of a different section of the rules to the advice that had previously been given. And looking at the IBA rules, well, they didn't mandate disclosure of the advice that had been provided over 3 years earlier. Now, the judge commented that 2 of the more recent instructions should have been disclosed. They didn't meet the 3-rule test, but they didn't really relate to the issues in arbitration or show any ongoing relationship. And the RBA rules didn't require disclosure of the prior appointments because the arbitrator hadn't been appointed more than 3 times in the 3 years prior to the arbitration. Now, the key test and what the judge was interested in and what the fair-minded and well-informed observer would be interested in was, well, could it be said that the arbitrator was financially dependent on work from the Premier League or work from the particular solicitors? Had that arbitrator been nominated so many times by the firm of solicitors that there was the hint at an ongoing relationship? Or had the arbitrator given so much advice to the Premier League that made up a reasonable chunk of their income? And that hadn't happened here. There were one or two other matters of interest. The arbitrator had needed consent of Premier League to disclose the earlier advice. The judge couldn't actually resolve the issue about the advice without knowing what the advice was given. And that was fair enough. The arbitrator could write to the other side and ask for that. But what the arbitrator also did was ask the Premier League solicitors' views about whether they should recuse themselves. And the judge thought that was an error of judgment and it went too far. But again, the judge looked at the overall picture and it didn't go too far to mean that the arbitrator should actually be removed. The judge looked at the overall picture. He looked at the whole thing. The weight of the whole does not exceed the sum of its parts. So they looked at the reputation of the arbitrator. Now, it's interesting that the courts do that, because I think very much the Supreme Court did that in the Halliburton case as well. And you do have a slight question mark. Reputation shouldn't matter. It should be, I think, when it comes to conflict of interest, particularly when it's a decision maker, it's much more important than that. But looking at it as a whole, well, there wasn't anything to suggest that the arbitrator could be considered biased in any way just because of these prior appointments. As Sam was saying, experts get appointed on many projects. Arbitrators too get nominated on many disputes. And something that's of interest in this particular case, the Newcastle case, was that it was a sports arbitration. And apparently there's a very small pool of good, well-respected arbitrators who deal with sports arbitrations. So it may be that from a construction context where there's a much larger pool of well-respected potential arbitrators, the decision would have been looked at slightly differently because there's more choice. So that was some of the things that we just wanted to just highlight about conflicts of interest, and some of the things that we wanted to highlight about developments in arbitration. There's been quite a lot over the last few months, so we may need to repeat this in a few months if the speed of information keeps coming up. But there's just time to deal with a couple of quick questions. Olivia, one that came in whilst you were discussing the Sierra Leone case. Do you think that the court would treat the FIDIC amicable settlement period in the same way as the court treated the Sierra Leone contract?
Yeah, I think the key point to bear in mind about the Sierra Leone case and the time period in there was that it wasn't set out as an independent waiting period. So it was, as I think both the court and the tribunal found there, it was tied to the aim of achieving an amicable settlement, which in the circumstances was found to be very, very unlikely between the parties. And that's not the case under, I think it's clause 20.5 of FIDIC. But I think that clause, which is the one which requires the parties to attempt an amicable settlement, I think that clause expressly says that arbitration may be commenced 56 days after a notice of dissatisfaction, even if no attempt at settlement has actually been made. So I think it's pretty clear there that there's that's basically an independent waiting period, because it applies regardless of whether the parties even try to settle. So I think the short answer is no. I don't think, the clause 20.5 of FIDIC could be treated the same way. Okay,
no, that makes sense to me. Sam, and I'll hopefully I'll get this right. Is there any concern that the finding that the duty to avoid conflict was owed by the whole group and not one particular entity? Is there any concern, conflict with the idea of sort of possible difficulty with piercing the corporate veil?
Yes, so that was raised as one of the arguments, but I think the court here wasn't too concerned about that, because the issue was the way that the international, well, sorry, it was the way that the group represented itself. And I think when they talk about, Secretariat, it's talking about the international group as a whole. When they carried out their conflict checks, there was certainly it was carried out across all companies within the group. So the court here didn't think that there was any issues of piercing the corporate veil here, because it just depended on how they presented themselves to clients. They did say that, you know, a company like this could do conflict checks and in a way that makes it clear that the conflict check has been carried out by one distinct entity within that group, such that other entities are free to carry out whatever work they choose. But I think the court did note that whether or not they're able to win instructions on that basis is a completely different question.
Okay, yep, no, thank you. And I see I've just been asked, I hope it's a tongue-in-cheek question, as if we're going to sort of eventually see the end of witness evidence, and we don't need to take witness statements. Well, it'd be quite nice not to have to take witness statements, but no. I don't think so. It might be a case, I suppose, of the end of, in a few years' time, we might see the end of witness statements as we know them today. I mean, I think there's rightly a lot of discussion about the role of witness evidence. And I think there's just a concern amongst decision makers, well, they want to get the decision right. And if there's a concern that sometimes, that for whatever pressures are, there's a doubt about the witness evidence, what do you look at? What's the most reliable form of proof? And I think where it's leading to is that people are going to focus more on the contemporary documents. So it might mean the way that we run disputes, whether it's arbitration, dispute boards, adjudication, changes. But I think there's always going to be a place for witnesses. Perhaps it'll just be done in a different way. But it's a really good question, and we'll just have to see how that one plays out. So I think that's all we really have time for today. So thank you all very much for attending. Thank you all very much for your questions. As I said, we will be sending out the slides to you later. And just leaves me to hopefully say that we will see you in 2 weeks' time, Thursday, the 6th of May, when my colleagues, fellow partners, David Bebb and Lucinda Robinson, will be discussing starting off on the right foot. Now, I'm not entirely clear maybe from that what their webinar is all about, but it's all about the formation of contracts. Absolutely key issue. One of the top causes of disputes, as we were discussing earlier, is failure to understand what your contract says. Start off on the right foot, get your contract formalities all done in a correct and proper way. Bob's your uncle, less disputes. So hopefully you'll be able to join David and Lucinda in a couple of weeks' time. And until then, goodbye. Thank you very much for your time and attending. We look forward to seeing you soon.